Thank you for your thoughtful questions. About question one, why not Switzerland or other neutral countries? The reality of Snowden's situation was far more complex than simply choosing any non-NSA affiliated country. First, let's consider practical geography. Switzerland is completely surrounded by NATO allies: France, Germany, Italy, and Austria, all countries with close intelligence sharing relationships with the United States. This creates a significant vulnerability. Even if Switzerland itself wasn't cooperating with the NSA, Snowden would have been at risk during transit through Allied airspace. In fact, the US actually forced down Bolivian President Evo Morales' plane in 2013 based on mere suspicion that Snowden might be aboard. Imagine the pressure they could exert on European nations. Second, Switzerland has one of the strictest naturalization and asylum processes in the world. Snowden needed immediate protection, not a years-long legal battle for residency. Russia and China, whatever you may think of their governments, could provide immediate asylum without US extradition, a practical necessity for someone in Snowden's situation. Ultimately, Snowden's limited options don't invalidate his whistleblower status. The question isn't where he fled, but why he had to flee at all after exposing unconstitutional surveillance. About question two, what defines a whistleblower? A whistleblower is someone who discloses information about an authority's practices to those affected, believing it exposes ethical or legal wrongdoings, and does so contrary to how the authority would present it. Snowden fits perfectly. He disclosed surveillance programs to the American people being surveilled. He genuinely believed these programs violated the Fourth Amendment, later confirmed by a 2020 federal court ruling. And he disclosed only after his superiors ignored his internal concerns. About question three regarding the 1.7 million files and supposed negligence, yes, Snowden took approximately 1.7 million files. However, the critical distinction here is what he did with them versus what was actually published. Snowden didn't dump all 1.7 million files onto the internet. He gave them to experienced journalists who then carefully reviewed and redacted the material before publication. This was a deliberate choice to balance transparency with national security. As Snowden himself stated, his intent was to inform the public about surveillance affecting them, not compromise legitimate intelligence operations. Regarding the Espionage Act, this 1917 law is unconstitutionally vague when applied to whistleblowers. It was designed for foreign spies, not government employees exposing domestic constitutional violations. The Act's language about information used to the injury of the United States is subjective. Even the National Whistleblower Center's Stephen Kahn stated in The Guardian that the Espionage Act isn't an appropriate tool for policing responsible disclosures. If there was genuine negligence causing harm, the government should prove it in court. Yet they refused to offer Snowden the fair trial he has repeatedly requested, a Sixth Amendment violation that itself undermines the legitimacy of the prosecution. So in sum, Snowden's limited asylum options don't negate his whistleblowing. His actions fit the clear definition of whistleblowing, and concerns about file volume ignore both his use of responsible journalists and the constitutional problems with his prosecution.